is that you learn something today that will better assist you in establishing, enhancing, and protecting your estate. But before we get started, let us receive the Decatur Alumni Chapter's second Vice President as she brings additional greetings. Mrs. Rosalind Burns Fowler.
Good afternoon and good evening, everyone. I bring greetings to you this evening on behalf of our chapter president, Angela Sanders, who could not join us this evening. I'm sure that she will be elated to see so many people joining us this evening for our Economic Development Committee's final financial management webinar for our fiscal year. Since last year, November, our over 530 chapter members, surrounding community partners, and citizens from around the U.S. have been able to log in from their computers to learn from experts who have helped us to make the right decisions as it relates to our finances and our wealth building. I also want to offer my sincere thanks and express gratitude to tonight's presenter, Attorney Taire, for her willingness to share her expertise with us this evening. May I encourage you, our guests, to take notes and ask questions. Fortunately for all of us, this session is being live streamed on our Facebook page, which means that you and I can always come back to listen whenever we need a quick review. Please be sure to like and follow us on our social media channels and visit our website for updates as we continue to offer helpful sessions that bring enrichment to everyday life. Again, thank you for joining us.
Teresa, you're on mute.
Today's webinar will allow interaction between the presenters and the attendees. Attendees can interact via chat. There will be an opportunity for questions using the Q&A option. We will have someone monitoring that session. This webinar is live on Facebook and also will be available on YouTube after May 1st. We will now have the introduction of the speaker.
Good evening. I'm Lisa Anthony, a member of the Decatur Alumni Chapter of Delta Sigma Theta Sorority Incorporated. This evening, I would like to introduce our speaker and give you a little bit of her background. Jammie Taire is a Georgia native who graduated from law school at Georgia State University. She has been practicing law for over 20 years. She started her career at a firm in Gwinnett where she oversaw the will division. She then went on to start her own practice in 2006. She has been in private practice for over 10 years. She currently handles estate planning and probate. She also serves as a magistrate in Gwinnett County and serves as the chief judge for the municipal court of Snellville. She is married with an 11-year-old son. And now we introduce to you Attorney Jammie Taire. Thank you.
Hello. I am so excited to have this opportunity to speak to you all today. While we were beginning, I heard this song play, She Works Hard for the Money. I thought, well, that's quite relevant. That's the perfect song for tonight because she works hard for the money. And my job today is to teach you how to protect that money and to teach you how to make sure that money goes where you want, when you want. Thank you, Lisa, so much for introducing me. As you heard her say, I am a Georgia native. That means I am a grit, a girl raised in the South. I am proud of that. I attended school at Avondale High School, and I went on to go to law school at Georgia State University. It is such an honor and privilege to be here with you all today. If we could start that presentation. Thank you. Next slide. So I've been asked today to talk to you about minding your estate. You've heard a little bit of information about me, but I want to give you a little bit more because before I go forward, I think that you would want to know who you're talking to and whether or not you can rely on the information I'm giving you, right? So I have been in practice since 1998. Yes, I know I don't look old enough to have been in practice that long, but it's a fact I have. I've actually been practicing since 1998. I opened my own firm in 2006. And when I first opened my firm, I did primarily family law. I still, because of my background at the other firm I worked for, I still did a little estate planning, but primarily I was a litigator. I did straight family law. Well, I was lucky enough to be appointed as magistrate, part-time magistrate in 2018. After I was appointed as a magistrate, I decided to move my practice from family law into estate planning and probate. Estate planning because I've always enjoyed handling wills, teaching people about trust, talking to them about estate planning and how to protect their assets and to make sure their loved ones were cared for. So that was a natural progression for me. And then also probate. Probate, I always call it basically family law or on steroids, because instead of dealing with two people, many times you're dealing with large families, especially in contested probate cases. So now my firm handles exclusively estate planning and probate. Next slide. Of course, I'm a lawyer, so I have to put this disclaimer out there. This presentation is for information purposes only. I cannot say that this creates an attorney-client privilege, and each situation is different. So you would be advised to consult with an attorney. As I said, we will have a question and answer section, and I will answer as many questions as I can, but in some cases, I would tell you to either call my office or reach out to an attorney for additional information. Next slide. So what are we going to talk about today? Well, you know already from the topic, we're going to talk about estates. So some of the things that I hope that we get covered are important reasons to do estate planning, some of the basic documents that I recommend to my clients when they come in for estate planning. We'll do some talk about trust and of course, some talk about probate. Next slide. So let's start with, so I'm going to tell you who these kids are first. The little Spider-Man is my Martin. That's when he was very young, and that's a friend of his. And I picked this picture because this describes why you estate plan. It's for your family, to make sure that your family is protected. So exactly what is an estate? Let's start with that. A lot of times when people hear, why do I estate plan, or what is an estate? I don't have an estate. I don't really need to come to you because I don't have anything. Well, an estate is simply your stuff. That's how I always describe it to people. Whatever you have is your estate. So even if you don't have a house, you still have an estate. Your clothes make up your estate. Your car makes up your estate. The money that you have in your bank account, all of those things make up your estate. So if you have taken the time to acquire those things, to work for those things, then you have an estate and you should have a say-so in what happens to those things. Why do you need to plan? Because you worked hard. You've worked hard for those things, and you would want to decide where they go. You don't want the state to have to decide where your stuff goes. Next slide. So today, what we're going to talk about first are 3 basic estate tools. Whenever someone comes into my office and they say, hey, Jammie, I need to do an estate. I'm not really sure what I need to do. What do you recommend? Before we get into too far in the weeds, I say there are 3 things that I always recommend that you do. That's a will, a durable power of attorney, and an advance directive for healthcare. During this presentation, my goal is to walk you through each of these documents to help you understand them and to let you know why you need them. Next slide. So we're going to start with the will. What is a will? A will is a written document that outlines where you want your things to go at your death. The will doesn't really take effect until after you pass, so it becomes valuable at your death. Next slide. What are the basic requirements for a will? Now, in each state, the requirements are going to be different. Of course, this presentation is limited to what's valid in Georgia. So in Georgia, there are 3 things that you need in order to have a valid will. First, you need to have capacity to make a will. Well, what does that mean? That means in Georgia that first, you only have to be age 14 in order to have capacity to make a will, and you have to be competent. The law presumes that you're competent. So even if you think Uncle Willie is crazy, the law presumes that he's fine unless it's shown that he is not. It has to be in writing. Sometimes people say, well, I want to do a video will. You can do it, but that's not valid. We still have to reduce it to writing. Writing means it can be handwritten or it can be typed, but it must be in writing. An oral will is not valid. Some deathbed wills are not valid if they are not in writing. So that will must be in writing. And finally, it must be properly signed and witnessed. And what does that mean? That means that it has to be signed by the person doing the will. Now, what if they don't have the ability to sign? They don't have to physically sign it. Someone can read it to them and someone can sign on their behalf. But whoever the witnesses are will have to attest that the person understood that the person was signing on their behalf and they understood what the will said. It must also be witnessed by 2 people who are not in the will. That is very important because if 2 people witness it who are in the will will still be deemed to be valid, but whatever those 2 people were going to receive, they will not get. And that goes to the accidental disinheritance. So say for instance, an example, say for instance, I do a will and I leave everything to my husband and son. And then my husband and son witness the will. Then my husband and son do not take under the will because they are interested parties. So it's very important that it's by 2 people who are not in the will. Sometimes people ask, well, does it have to be notarized? It does not have to be notarized in order to be a valid will. It simply needs to be signed by the testator and also witnessed by 2 disinterested parties. Now, a prudent attorney will do another page that's called a self-proving affidavit. That's the page that's notarized that people are often referring to. That ensures that when someone admits the will to probate, they don't have to go looking for the witnesses. If it doesn't include the self-proving affidavit, when it goes through probate, then you have to go and find the witnesses. If you can't find the witnesses, then you have to find people who are familiar with the testator's signature. So it's very important to try to have that self-proving affidavit included on the will. You'll see a lot of older wills won't have the self-proving affidavit. It's still a valid will if it's not notarized. It just makes it a little more difficult at the probate process. Next slide. So with the valid will, what can you do? You can choose who inherits your property. That's the most important part, of course, because you want to have a say-so in who gets your stuff. Who will administer your estate? What that means is you get to appoint the executor over your estate. Who will care for your minor children? Now, this is very important because in a trust, you cannot do this. With a will, you do get to decide who will be the guardian over your minor children. Now, if you're married and the children are born of the marriage, then naturally it's going to be your spouse. What if you're not married? Then who's the guardian? We see this a lot, and this sort of crosses over into the family law part of the conversation. If you're not married, then the mother or father of your children can step up, and most likely they will be appointed as guardian, or the children will go to them. But what if they are not around? Then the court will look at your will to see who you would like to have appointed as guardian over the children. You can even create what's called a testamentary trust through the will. So even if that mom or dad that you don't get along with gets the children, you get to decide who gets your child's money, and more importantly, how they're going to disperse it to your child. Next slide. So in Georgia, your child is considered a minor until age 18. So as I was just saying, the will allows you the opportunity to decide who takes care of your child. And even if the mother or father who you're not married to and you might not necessarily trust get the child, you get to at least say, well, they may get my child, but I want this other person to take care of my child's money, and this is how I want them to disperse it to them. Next slide. So why do you need a will? Peace, provision, and protection. Next slide. What happens if you do not have a will? Now, this is very important because I get this question often. Well, you say I need a will, but why? Well, this is why, because in Georgia, if you don't have a will, then the state decides how your property passes. They don't take your property. We get that question a lot. The state won't take your property, but they do get to decide how your property will pass. For example, say for instance, you're married and you have children, and it doesn't matter whether they're adult children or minor children. In Georgia, if you die without a will, then your property passes to your spouse and your children equally, with your spouse taking no less than a third. So say for instance, you have 4 children and your spouse, then your spouse would get 1/3 of your estate, and those 4 children would split the 2/3 of your estate. A lot of times people don't want it to pass that way. And so if you don't want that to happen, then you would need to make sure you have a will. Well, what if you're not married? What happens? Well, if you have children, it passes equally to your children. What if you're not married and you don't have children? Well, in that case, it goes to your parents. If your parents are deceased, it goes to your siblings. If you don't have any siblings, then it goes to your aunts and uncles, and so on and so on and so on. So the state has already made a plan for you. If you haven't made a plan, as my husband says, if you don't care, somebody cares for you. So if you don't make a plan, the state has already made one for you. And if you don't want to see that happen, then you need to make sure you have a will. Next slide. Potential issues if you do not have a will. Accidental disinheritance. Well, what's that? It goes with the blended families comment that's right below that. If you have, a lot of us are in blended families nowadays. So that means you have a stepchild, and say for instance, you pass. And you may want that stepchild to get something. Well, if you don't have a will, then that stepchild won't get anything. And that's what we mean by accidental disinheritance. Next slide. So do I need a will? I know I've gone a little fast through this, but I hope that I have been able to convey to you that you absolutely need a will. If you want a voice in how your property is distributed, then you need a will. If you want to make sure that your assets are protected, then you need a will. Let's go back to that example I gave when I was telling you, if you don't have a will, then your property passes to your spouse and your children, with your spouse taking 1/3. Well, what also happens that I didn't mention in that situation is if you have minor children, then the court can appoint a guardian ad litem over that minor child, even though it's your spouse's child. The court can also appoint a conservator. So now you have the state that your spouse has to report to because there wasn't a will. So now they've appointed this third party and they have to report to them because you didn't have a will. And more annoying, even if they're appointed as the conservator, if your spouse is appointed as the conservator, every year they have to give a report to the state or to the court to say what's happening with the money that your child inherited. That's something that most people definitely do not want. Also with guardianship, if you have a child and the mother or father isn't around, then you want to make sure that you have some say-so in who's going to serve as guardian over your child. You want to make sure you make provisions in the event the unexpected happens. Next slide. Once you've done a will, it's also equally important that you update your will. We check in with our clients a couple every year to make sure there haven't been any changes with their estate. Changes include you have a child added to the family, marriage, or divorce. This is important because if you get married or divorced, then that could have an impact on your will. It won't invalidate the will, but it could make some of the things pass according to the laws of intestacy. If you move to another state, moving to another state does not invalidate your will. However, if you move to another state, you need to make sure you have someone in that state review your will. And any significant passage of time, of course, you need to just take a look at your will to make sure maybe the person you've appointed as executor is still around, you still have a relationship with them, or the person that you appointed as guardian or trustee, that you still have a relationship with them. And sometimes if your child has aged up, then you may appoint that child as the executor over the estate, or you might no longer need those guardianship provisions. Next slide. Before we move on to durable power of attorney, after each section, I think it's important that we do a Q&A just to see if there are any questions. Do you have any questions, or do you show any questions about the will?
Yes, Attorney Taire, we have several questions. The first one, what are the benefits of a will if your only assets are financial accounts and you already have beneficiaries tied to those?
Well, you still, sometimes you might think you do. Banks are funny. We have people come to us all the time with issues that they run into with the bank. Even when they have a POD or a TOD is what you're referring to. That's a payable on death or a transfer on death. So if there's any hiccup in that system, then that will serve as a backup.
Okay.
Also, sometimes what happens is you'll get checks, or a person will receive checks after you pass in your name. And so they would have to open an estate account in order to cash those checks. And if you want to decide who gets that money, then you would need to have a will.
So does that also pertain to like 401ks and those types of accounts as well?
So anytime you have and we'll get into that a little bit when we get into the probate session, but anytime there's a named beneficiary, then that falls outside of probate. So when you have life insurance policy, 401k, IRAs, anything where you have a named beneficiary falls outside of probate. Now, in some instances, people leave their estate as the beneficiary. And of course, in that case, they will look to see what your will says.
Okay.
And in some cases, I'm glad you asked that question about is all financial. In some cases, people haven't updated their life insurance policy. So whomever they named as the beneficiary is no longer around. So then again, we would need to look to your will.
So the will always overrides beneficiary?
No, that's not what I said. No. The will does not override beneficiaries. The beneficiaries override the will. So anytime you have a named beneficiary, it falls outside of probate. So if you have a life insurance policy, that has nothing to do with probate. If you have a 401k and you have a named beneficiary, it has nothing to do with probate. Now, if you do not have a named beneficiary, then it comes in.
Okay. Do all wills have to be probated?
All wills have to be filed with the, or should be filed with the court, and the executor is afforded a reasonable amount of time, which has not been defined, in which to file that will. So if they don't have real estate, usually they can just go on and file the will with the probate court and even do a petition for no administration necessary. But if they have real estate, then they would need to probate the will. But all wills must be filed.
Now,
Or should be.
Okay, so you talked about non-biological children, but an accidental disinheritance. So if you don't have a will, and so they're not, I guess,
stepchildren are not included. That's correct.
They're not, okay.
And this is also, so your stepchildren aren't taken care of. And in Georgia, I didn't want to get into this too much, but there's also something called years support. So the spouse could always apply for what's called years support. And if you wanted your adult children who are not the children of your spouse to get something, it's possible that they could be left out because that spouse applied for years support.
Okay, and then finally for this section, what happens if your witnesses are deceased? Does that invalidate your will?
No, that's where the self-proving affidavit comes into play. So if you have the self-proving affidavit, the court never has to look for the witnesses. If you don't have a self-proven affidavit, then they have to get affidavits from people who are familiar with your signature to attest to your signature.
Okay, and I'm sorry, we actually have a few more. Quickly, do joint accounts pass to that person? I'm not sure I
Yeah,
understand the question.
I
Okay.
understand the question.
Okay.
It's okay. So yes, a joint account does not go through probate either. The joint account goes to the joint account holder. So whoever that other person is on that account, the money passes directly to them.
Okay. And can a law firm be the executor of your will?
The person can. I've never seen a law firm named as executor, but a person in the law firm can.
Okay. And then finally, so can a person file their will at the courthouse, or do they need an attorney to do that for them?
No, a lot of people file their wills for what they call safekeeping. It's like $10 to file it. I generally don't recommend that for my clients because you have to remember to update it if you file it there for safekeeping. If you move out of state, sometimes people forget that they filed their will there. I have a case right now where the person filed their will back in the 80s and nobody knew that they had it, and it's causing all kinds of problems right now. And they probably forgot that they had filed it as well, and they never updated it. So yes, you can file it, and attorneys probably vary on whether or not they recommend that you file it.
And we have two questions from Facebook Live. One is stating, my kids are under 18. How do I set up a trust? For example, if I were to pass away when they're in their 20s, I wouldn't want them to have control of a large sum of money all at one time.
Okay, and there are two different ways, and we have a trust section that we're going to get to, but there are two different ways in which you can do that. One, you can either do what I call the testamentary trust, and that's where it passes through the will, where you're directing the trustee to set up a trust after you pass, or you can do what's called a living trust right now. And in a trust, you get to say how you want the money to be distributed and when you want it to be distributed. And we'll talk about that a little bit later.
Okay, and then the next question, so is an executor needed for a will?
Yes. That's a hard yes. You have to appoint someone to, so the role of the executor is to do what you say. So whatever you've outlined in your will, then your executor is responsible for doing that. So yes, you have to appoint an executor.
And
Now,
that can be anyone.
That can be anyone. It should be someone who you know is one gets along with whoever the beneficiaries are in your will. Someone who is maybe or definitely good with money, who's organized, and who is patient. Because probate is a long process. So now let's move on to the durable power of attorney. So I said that I recommend 3 basic documents whenever someone comes to me. First, the will. Next, this is the durable power of attorney. So what is a power of attorney? It is a document that gives someone broad or limited powers over your affairs. Next slide. What is a general durable power of attorney? And that's usually what people are coming to me asking for, is the general durable power of attorney. And those magic words, the durable part of it is the magic part of that power of attorney, because that's what makes it effective even if you are incapacitated. It's the same thing. It's giving someone power to act on your behalf. So you are the principal in a power of attorney, and you're appointing someone, also called an agent, to handle certain things for you, usually of an economic and financial matter. Next slide. These are the requirements for a power of attorney, and it must meet these basic requirements. Now, in Georgia, they recently, or not recently, in about 2018, They created a statutory form. So it's really just form-based, the power of attorney, but it must be signed by the principal. The principal is the person giving the power. As the same as with the will, if the person is unable to sign it, someone may sign on their behalf. But again, that gets real tricky. They have to know what they're signing. It has to be read to them. The principals have to attest that the person knew what they were signing, or the person can simply sign it with a mark. It must be signed by one or more witnesses. It really only requires the signature of one witness, but in my office, we always have 2 people sign it. And unlike the will, it must be notarized. And all of those things need to happen at the same time. So it needs to be signed by the principal, signed by one or more witnesses, and notarized all at the same time. Next slide. What can my agent do? When people ask me this question, when I'm doing a general durable power of attorney, I tell them they are you. So you just need to think whatever you can do when you do that power of attorney, they can also do it. They can pay your bills, they can call your mortgage companies, they can sell your house, they can file your tax return, they can do whatever it is that you can do. They are you. This is one of the most powerful documents, so you need to be very careful in choosing who you're going to appoint as your agent. Next slide. What happens if you don't have a durable power of attorney for health, not healthcare? What happens if you don't have a durable power of attorney? Well, let's just say, for instance, you're in an accident and someone needs to pay your bills and they need access to your bank accounts. Well, they won't be able to do that. I have a situation right now where they need access to the person's apartment, and they can't access the person's apartment because they don't have a power of attorney. And they keep having to pay the person's rent because the person is incapacitated and they can't access the apartment, and they're afraid that eventually they'll evict them and they don't want their possessions put outside. But if they had a power of attorney, they would be allowed to access that unit. Next slide. This is a big one, and this is why I said this is a very powerful document. The power of attorney does not require incapacity unless the document specifically states it. When you come to my office, I do put language in there that says that it is limited and it's only in the event of your incapacity, but that is not automatic. It gives broad authority and it does not require incapacity. So you are hearing me correct when I'm saying that, yes, you can be out here minding your business. If you've given somebody a power of attorney and is not limited by your incapacity, they can also use that power of attorney simultaneous with you. Now, of course, they have a fiduciary duty and responsibility to you to not abuse it, but you have given them the right to act on your behalf, despite your incapacity if you do not have limiting language in it. Next slide. I've already gone over that. Next slide. Okay, any questions about the power of attorney? All right, if not, we'll move on to the Advanced Healthcare Directive. Next slide.
I'm sorry, one question
Mhm.
regarding the timing of these 3 documents. So do you suggest that a person gets a will, power of attorney, and healthcare directive all at the same time just to cover everything?
Oh, yes. So at the beginning, whenever you come in and you say, what do I need, Jamie? I say, you need a will, a power of attorney, and an advance directive for healthcare. Now, the power of attorney and the advance directive for healthcare is during your lifetime. The power of attorney dies when you die. So it's because, remember, a power of attorney allows someone to be you. So of course, when you pass, you're no longer allowed, you can't access any accounts. So anyone acting under a power of attorney can't access any accounts either. And that's when your will kick in. So the power of attorney and the advance directive for healthcare are good during your lifetime, and the will takes effect at your death. And yes, you should do all 3 documents because you want someone to be able to do certain things during your lifetime if something happens to you and you're incapacitated, but also you want to provide for what happens at your death.
Okay, that was it. Thank you.
In that is a good segue into the advance directive for healthcare. So just like the power of attorney is good during your lifetime and controls your finances, then the advance directive for healthcare controls your medical situation. Next slide. What is an advance directive for healthcare? As I just said, this gives someone control over medical decisions. So while the power of attorney generally involves economic and financial decisions, the advance directive for healthcare involves medical decisions. You will have also heard an advance directive for healthcare. People refer to it as a living will or a power of attorney, a medical power of attorney. Next slide. What does an advance directive do? It allows you to appoint someone to make medical decisions for you in the event you are unable to make those decisions. So unlike the power of attorney, where it requires limiting language, in the advance directive, it says this is in the event of your incapacity and you're unable to make decisions for you. This is very important because you may want to have some say-so in who is going to make those decisions in the event of your incapacity. Now, if you didn't have one, they would go to your next of kin. But what if they can't get along? What if they can't make a decision? What if they can't make a decision together? I'm not sure of the age range of the people on this presentation. Well, I am a little bit, but I'm sure many of you remember the Terry Schiavo situation, where you had the parents and the husband fighting over what's going to happen to this person. Had there been an advance directive for healthcare that gave clear instructions on who the hospital was to turn to, that would not have happened. And that goes into the can avoid court involvement, because the court had to get involved in that situation. However, if she said, I'm giving this power to my husband, then that wouldn't have been the case. It allows you to make decisions in advance. So the advance directive for healthcare now includes a living will component where you get to decide whether or not you want to be on life support. Now, you don't have to make that decision, and you can say that you rather whoever you appointed as your agent to make that decision. But if you know that you don't want to be on life support, when you do your advance directive for healthcare, then you get to make that decision. Next slide. But I'm not old. I don't need an advance directive for healthcare. I don't think that I'm going to be incapacitated. I don't have those kind of problems. You still need one because, as we all know, sometimes life happens and the unexpected happens. So you just want to make sure that you're prepared and that you've appointed the person that you want to appoint to make these decisions for you. Next slide. You also get to the benefit of relieving your loved ones about medical decisions. I think one of the hardest things to do is to decide whether or not you want to discontinue life support when you see somebody on life support. I've had that situation in my family, as I'm sure many families have. And even though you may know that the person doesn't want to be on life support, it is hard sometimes to make that call. If you have an advance directive for healthcare, you get to tell your family in advance what to do, and that will relieve them many times of the burden of making that decision. Next slide. So why do you need an advance directive for healthcare? If you are unable to communicate, if you're in a horrific accident, then this gives direction to your family and to the hospital on what they should do. If you've ever been in the hospital, most likely you were asked whether or not you had this document. Next slide. Next slide. So when does it take effect? It takes effect right now. Unlike the durable power of attorney where you can limit when it takes effect. So with the durable power of attorney, you can say, well, I want it to take effect only upon my incapacity. With an advance directive for healthcare, it takes effect right now. Next slide. Any questions about the advance directive for healthcare?
I have one Facebook Live question, or actually two.
Okay.
The first is, what would be the average cost for creating the 3 documents?
It really depends on your situation. You know, we don't just give out prices like that. But it really depends on your circumstances and situations. For my office, if it is a very basic will, power of attorney, and estate planning, it starts at $750.
Okay, and do living wills have expiration dates? Are they able to be updated?
They don't have expiration dates, but you can revoke it. In the document, it says that this will be revoked upon written notification from me to my agent. And anytime you do a new one, it usually says this revokes your previous living advance directive for healthcare. And that's the same with the power of attorney. So the power of attorney is in effect until you revoke it, unless you have language in there that revokes it.
Okay, that's it from Facebook for now.
Okay, I think somebody just said they were unable to submit a question, but it popped up real quick, so I wasn't able to read it. I'm sorry.
I have a few here.
Here, oh, go ahead.
And I lost it. So where should an advance directive for health insurance be filed or located? Does it have to be filed with the court?
No. So for the advance directive for healthcare and all three of those documents, I generally advise that you keep them in a safe place, like a safe deposit box or a fireproof box in your home. If you choose to do a safe deposit box and you want to check with the bank to find out what the rules are for accessing the safe deposit box, with your advance directive for healthcare, then you should just let your family know where you keep that. If you're going in for surgery, then usually the hospital will ask you if you have one. You can provide a copy to them. You won't need to provide the original to them. With the power of attorney, because that document has a lot more power, and you should just tell your agent where you keep it, or your family where you keep those documents. And no, they do not need to be filed with the court.
Okay, there's a question about business. So assume you're the sole owner of a business. To dictate what happens to your business accounts, what documents do you need?
Ooh, okay. So we're about to talk about trust. So a trust is a helpful tool if you have a business, and we'll get into that a little bit. You can also outline that in the will, but really you need to outline that in your business documents, either in the bylaws or the covenants, but that probably needs to be dealt with through the business. But another way you can deal with it is through your trust. And so let's roll on into the trust conversation. Next slide. Let's talk about trust, baby. Next slide. What is a trust? So I think that there are a lot of myths out there about what a trust is. Basically, a trust is just a separate, I call it a person. It's a separate person who now houses your stuff. I've also heard it referred to as a bucket that you put your stuff into. So depending on what type of trust it is, it's not necessarily, it doesn't necessarily require a separate EIN number or anything like that, but it's a bucket that your stuff goes into. Next slide. The most common types of trust are testamentary trust, revocable trust, irrevocable trust, special needs trust, and pet trust. So a revocable trust is also referred to as a living trust. So usually when people call in, they're asking me about a living trust. A testamentary trust, we've already touched on a little bit. That's the trust that you establish through your will. So in your will, you may say, if you have minor children, I wish to leave my assets in trust to a named trustee. And that's a testamentary trust where it only takes effect through the will. Next slide. A revocable trust is just like it sounds like. It is a trust that you can revoke. So let's go through the different stages of a trust. First, you have the grantor. The grantor is the person who is giving the stuff to the trust. Usually with a revocable trust, the grantor and the trustee are going to be the same person, because you're the person giving the stuff and you're also the person receiving the stuff. Typically by stuff, I'm referring to real estate. So let's just say, for instance, you have a house and your house is currently titled to you. Once you establish that trust, the house would no longer be titled to you. It would now be titled to your trust. So it go from Jammie Taire to the Taire Family Trust. So the title changes. So now that property no longer is in my name, it is now in my trust name. But it's revocable because at any time I could change that. There's also the irrevocable trust, which generally you don't see people use a lot because you no longer manage the irrevocable trust. Someone else is the trustee over that irrevocable trust. But usually people establish irrevocable trust for trust protection. Some of the benefits of a living trust or a revocable trust is first, it prevents probate. So usually when someone comes to me and say they want to establish a trust, the reason why they're saying they want to establish a trust is because they just had a loved one pass and they had to go through the probate process and they don't want to go through that process anymore. And a trust can help avoid having to go through the probate process. Secondly, it helps you keep your settlement private. A will in probate is public. It's filed with the court. You can go down there, you can ask for someone's file, and you can see that information. The same is not true with the trust because it is not filed with the court. In some situations, depending on what type of trust you have, it may minimize estate taxes. Georgia doesn't have estate taxes, so that's not really relevant. It does help you dictate the terms of asset distribution. So through the trust, just like in the will, you get to decide how your property is going to be passed. But unlike with the will, usually with the trust, we outline more detailed terms with how that property is going to be distributed. And you don't have to really worry about that accidental disinheritance because in the trust, you can provide not only for your stepchildren, but your biological children. And because it becomes irrevocable at your death, you don't have to worry about your spouse changing it and leaving out your biological children after you pass. You also heard me say that pet trusts are popular now because they allow you to provide some provisions for your pet, which can be nice. Next slide. So what is the difference between a will and a trust? Well, I touched on some of those already. A trust is private. You don't have to tell anybody about the trust. It's not filed with the probate court. And the only people that know about it are the trustee and the beneficiaries and you. It does avoid probate. Now, let's talk about that a little bit. What happens a lot of times is someone will come to me with a trust after someone has passed. And basically, they just have a bunch of papers. One of the things you have to make sure of when you're doing a trust is that you actually do what's called fund the trust. And that's why it's really important that you seek legal advice, but even in seeking legal advice, also understand the process. Because I have had people who came to me, they have a trust, but they never put anything into the trust. So they still have to go through the probate process. If you don't put any assets in the trust, I tell them you just basically have a whole bunch of paper because there's nothing in that trust. So that example I gave you about the house, for instance, now you funded the trust. You may choose to put some of your bank accounts in that trust. You may choose to put your CDs in that trust. So it's important that you change that title from your name into the name of the trust. And that way you can completely avoid the tax consequences. Next slide. Any questions? I'm sure I went over that pretty quickly. Any questions about trust?
Can you put stocks in trust?
You can. However, if you have a named beneficiary on there, you may or may not want to, but yes, you can put stocks in trust. Usually with IRAs and stocks, we don't recommend it because sometimes it can have significant tax consequences. So we would need to sit down and take a look at it first.
Okay, what is the protocol if a single estate has been documented in two separate trusts?
Oh, go ahead.
I'm sorry. What is the protocol if a single estate has been documented in two separate trusts? Will one override the other?
What?
If one estate, I guess, if your home has been documented in two different trusts, I don't know if that's possible, but will one override the other?
Yeah, you have a problem. If that has occurred, one of those isn't valid. So, because say for instance, I have a property that's in my name, and then I transfer that property from my name into the name of the trust. So now the property belongs to the trust. So if I did that on August 1st of 2020, and then on August 15th of 2020, I went to transfer that property into another trust, that August 15th isn't valid because I no longer own the property as of August 1st. The trust owned the property after August 1st. So I no longer have the ability to transfer it from me to another trust. Now I can transfer it from that trust I transferred it to on August 1st to the other trust.
Okay. Will the children have to pay taxes on items in your trust, like cars or real estate?
No, Georgia doesn't have a state tax.
Okay. And what are the steps for setting up a trust?
Well, usually we will send out a questionnaire, and then once you've completed the questionnaire, we review the questionnaire, we prepare the trust. That's the easy part because that's just paperwork. The important part about the trust is funding the trust. So after we prepared it, then we start titling property in the name of the trust. The things we typically title in the name of the trust are real estate. Sometimes we put bank accounts in the name of it. We put CDs in the trust. So the important part is what we're putting in the trust, not really the preparation of the documents. So by funding, I mean putting things in the trust, like the house. Funding means taking it out of a person's name and putting it in the name of the trust. That's called funding the trust. Putting stuff in the bucket.
The last question in the chat, if I have a home that isn't titled as joint survivorship with spouse, can I still put the home in trust for my children?
Yes, so you can put your interest in the trust. If you and your spouse agree, then of course you can title it from you and your spouse to the trust. If it's only your interest that you're putting in there, then that's all you can transfer is your interest.
Okay, LaToya, are there any questions on Facebook Live?
Yes, we have two. One is in regards to the POA, and the other is in regards to a special clause in a will. Should we read them now or wait to the end?
Let's hold those to the end. I have two more on trust specifically. If my IRA has a beneficiary, but I want it to go to a trust for my grands, what can be done?
You would need to transfer it from that name or name the trust as the beneficiary.
Okay, and if your real estate is in the trust, can you still use the property as collateral for a loan?
Yes. So with a revocable trust, and that's what we've been talking about tonight, with a revocable trust, you still maintain ownership over that property. Nothing changes except the title. So you can still sell the property. You can still take loans out on the property. You can still do whatever you could have done when it was titled solely in your name.
Okay. And we touched on vehicles, but someone wants to know specifically, is that something that you would put in a trust?
I don't recommend it. It's so easy to transfer title to vehicles, and typically you don't even have to go through probate, that I don't recommend it. Now, if you have an antique, you might look to do that, but generally I don't recommend you titling a car in the name of the trust.
Okay. And with regard to real estate, does it need to be paid in full?
No.
Okay.
So before we end, I would really like the opportunity to talk to you all a little bit about the probate process, because the whole point of tonight is to talk about estate planning, but we've also sort of talked about it in relationship to probate. Well, what is probate? Why are people trying to avoid it? And is it something that I have to do? Next slide. Well, probate is the court process that determines first whether or not you have a valid will at your death. So this is important because this happens a lot. You have a will, somebody's done a will, the person passes, and whoever has been named as executor goes out and they just start doing stuff. Well, technically, that's not how it's supposed to happen. They are to now take that will, take it to court, file it with the court, and the court has first to admit it into court and then deem it to be a valid will and then appoint you as executor over the will. That's the part that many people are always trying to avoid because that can take some time. So, and people sometimes can contest it. They can say, well, they weren't competent, and now it can delay six months to a year. So the court has to first deem it to actually be a valid will. They have to look at the signatures. They have to make sure it's properly witnessed. They have to make sure that all the heirs have been notified. So in your will in Georgia, and this, I know this is different than Texas, in Georgia, if, let's just say, for instance, in your will, you left everything to your spouse and 2 of your children, but you disinherited 1 of your children. In Georgia, you still have to notify everybody that that will has been filed. Now, sometimes everybody will acknowledge it. If they don't acknowledge it, then the court has to have them served, and they have a certain time frame in which they can object to the filing of that will, the validity of that will, you being appointed as the executor over that will. So the will has to be filed in probate, and then the probate court determines whether or not it is a valid will. It also, all of that is part of it. Who will be appointed, who will receive your accounts and property, and that's depending on whether or not you have a will. If you don't have a will, it's considered an intestate estate, and it's the same thing. The court will have to still see who's going to be appointed and who will receive your accounts and property based on Georgia statute. The downsides of that is, of course, it can be expensive. So if it's an uncontested probate, meaning everybody is in agreement, then many attorneys, including myself, do flat fees. So that's not as expensive as if it's contested. If it's contested, who knows? It's looking like a family law case in that case, and fees can get up to tens of thousands of dollars, depending on how contested the estate is, and it can be very time consuming. We're talking about years, depending on how highly contested it is. Now, when I first started, I used to not necessarily tell people that they needed to have a trust, because the probate process, if it's uncontested, quite frankly, isn't really that difficult in Georgia, but it can be time consuming. And COVID taught us all that it can be really time consuming, because things that used to pass a little quicker, even with an uncontested estate, now has started taking months and months. And during that time, families are having to figure out how to pay mortgages because they don't have access to funds. They're trying to figure out, who's going to, mortgage companies aren't talking to them. They're trying to figure out how to avoid foreclosure. There are so many things that can happen during those valuable months that you're trying to wait for the probate court to get to your case. Next slide. Will my estate have to be probated? I think somebody asked this question earlier. So yes, your estate will most likely have to be probated. If you do not have a will, it will probably definitely have to be probated. If you have accounts that are only in your name, like your bank account, and you don't have a TOD or a POD, which is a payable or death or transfer of death, then yes, it will have to be probated, because that's the only way they can get access to that money. And that's with or without a will. So even if you have a will, it still needs to go through probate in order to do the transfers. So if you've left everything to your spouse, but the house is solely in your, or titled solely in your name, the spouse still has to go through probate in order to get that title transferred from your name to his or her name. Next slide. So what are the most common questions when people come to my office about the probate process? And somebody has actually already asked this question: how long does it take? It can go as quickly as 6 months and as long as many, many, many years. What's the quickest it'll go? So let me just walk you through the probate process real quick. Let's just say we have a situation where there is a will and it's uncontested, meaning that all the heirs are going to acknowledge and consent to whomever is appointed as the executor of the estate. So you come into my office, we'll prepare the petition for you. We'll send it out to the heirs because they all have to sign. So we have to send them the petition with a copy of the will, and they have to sign that and send it back to us. Once they get it back to us, then we file it with the probate court. After we file it with the probate court, you can take your oath. Most of the counties now are allowing you to do that virtually, so you don't have to go down there anymore. They'll allow you to take that oath virtually. Depending on whether or not we've asked for additional powers, then it may need to run in the paper once a week for 4 weeks. After that time, then the judge will appoint you as the executor over the estate. Remember, this is where there is a will and everybody's consenting. So we're looking at about a month, 2 months at the most. After you're appointed as the executor over the estate, then it has to run again in the paper once a week for 4 weeks. And that's the notice to creditors and debtors. And they have 90 days from the date of first publication in which to file a claim against the estate. So now you're 90 days out. So we're about 4 to 5 months out. After that 90-day period has expired, then you can hopefully go about the business of dispersing the assets in the estate, but that depends on what the estate is made of. So in the quickest situation, you're looking at probably about a total of 6 month turnaround time, but generally it takes a little longer than that. And how much does it cost? That depends on your particular case and how complex your case is. Ours generally start at $3,500, and that's a flat fee for uncontested. But it really depends on the circumstances surrounding your case. Next slide. How can I avoid probate? Next slide. There are a couple of different ways you can avoid probate, and some of them you have already touched on or asked about. The first one is what somebody mentioned, and others may not have known what they were talking about: a joint tenant with right of survivorship deed. That is a very good way or I call it a probate hack, to avoid that property passing through probate. If you are married and your property is deeded jointly with joint right of survivorship, then that property does not go through probate. In Georgia, it passes automatically by operation of law to your spouse. So that takes it out of the probate process. Next is a transfer on death or payable on death. So you can go to your bank and you can say, I'd like to add a TOD or a POD, depending on what your bank calls it. The good thing about this is that person doesn't have access to your accounts during your lifetime. So they're not joint on your account. This is just in the event of your death. And that takes me back up to number one. I want to mention real quick, do not name your children jointly on your property during your lifetime. It's not a good idea. I understand that we love our children. I love my child. It's just not a good idea to name your child jointly on your property for many reasons. One, if you and that child have a falling out, that child is now jointly held on your property. And before you can sell it or do anything with it, you got to get the permission of that child. Two, if that child has a credit situation and they get sued, they can lien your property. It's not a good idea to put your child on your property. Three, naming a beneficiary is another way that you can avoid probate. So I've gotten questions about life insurance. When you have a named beneficiary on that life insurance, it falls outside of probate. When you have a named beneficiary on that IRA or any accounts where you have a named beneficiary, it falls outside of probate. It is very important when you're reviewing your documents to make sure you update those beneficiaries. If you get divorced, you need to make sure you update the beneficiaries for your life insurance. If you get married, you need to look at the beneficiaries for your life insurance or anything else where you have a named beneficiary. And finally, as we have already discussed, creating a trust is a surefire way to avoid probate, provided that your trust is funded. Next slide. And that is all for me, unless there are some additional questions.
Yes, we have a few from Facebook Live. The first is in regards to a POA.
Okay.
If you do a durable POA and add the incapacity clause, do you have to go to court to decide incapacity?
No, you shouldn't have to go to court if you have that in there. But in that durable POA, there's also a provision in the statutory one anyway that says in the event that happens, then you're asking the court to appoint this person as your guardian or conservator.
Okay. Next question in regards to a will. If husband and wife both do a will and die in a common disaster, do we have to do a special clause?
No, so in the will, there's actually a provision that provides for that. The standard language, at least in my will, says that in the event my spouse survives me by 30 days, or in the event my spouse survives me, which shall be defined as 30 days, then it shall be presumed that I survive my spouse. So we have, a husband and wife have separate wills. So whatever your will say will go, and whatever that spouse's will says will go.
Okay, and the last in regards to a living will. If a living will is completed at the hospital, is that legally binding and permanent, or is that just for that hospital stay?
No, it's depending on the document, but generally the hospitals are giving out the statutory form, so it should be valid even after you leave the hospital. And I again want to touch on, and I know this sounds technical, is not really a living will, is the advance directive for healthcare. The living will is a component of the advance directive for healthcare.
Okay, that concludes questions from Facebook.
But it should be valid, because the last time I saw a couple of the forms that the hospitals were passing out, it's the statutory form, so you should be okay.
Okay, so I'm going to go back to the top. What age should you make a will?
The age when you start getting stuff. So I think the right answer that I should say is 18. That is probably a little young, but really the age would you start acquiring stuff. So, you know, nowadays people do get things a lot earlier. In Georgia, you can be 14 and do a will. So if you're 18 and you have some things that you want to decide how it goes, then you need to do a will. You know, if you want to decide who's going to get your collection of Air Jordans, then you need to do a will. If you want to decide who's going to get your Xbox, then you need to do a will. And I'm saying that if you're 18, because I didn't have a lot of stuff when I was 18, but it just depends on when you think is important that you get to decide how your stuff is going to go.
Regarding notarizing witness signatures for wills, does that requirement vary from state to state?
Yes.
If your will includes individuals in multiple states, how does that impact, or what is this? If your will includes individuals in multiple states, will that impact how you should write your will?
So I'm glad that question came up, because I didn't cover it. So that's important, because now that goes to why you would want to have a trust versus a will. If you have a will and you have property in different states, then when you die, your family has to go to each of those states to probate your will. So they have to do what's called an ancillary probate. So they have to go to all those different states to handle your affairs. Like I have a few clients, I have to send them to Florida. I have to get them an attorney in Florida. Then they have to go handle their affairs in Florida. Sometimes from California, attorneys will contact me and we have to handle their affairs here in Georgia. If you have a trust, you don't have to do that, because you can put all of the property in the trust. So then you don't have to go to all these different states, or your loved ones won't have to go through all these different states trying to settle your affairs. So
so that's,
if you're giving property to someone who lives out of state, no, you don't have to open probate in that state where they live.
mhm,
Whoever serving as the executor can just give them the property. Also, because so many of us have migrated from different places. If you have an executor who lives in a different state, that's okay too. You can name an executor who lives in Florida over your estate in Georgia.
okay. So back to joint accounts, how would the co-owner handle any checks received for the deceased?
Well, if it's solely in that deceased person's name, then that would have to go through probate.
Okay. But if it's jointly, if it's a joint account.
No, yeah, if it's a joint account, then all the money in that joint account goes to the joint account holder, but that doesn't give you the right to sign checks that's in somebody else's name,
Got it.
or endorse checks, I should say.
Mhm. So where can I find the forms to start a will and a trust?
Well, you see that information on the screen? I also offer an initial complimentary consultation if you'd like to talk about it, and that link is on the screen as well. And then I have that little QR code. If you scan it, that'll take you to my website, and you can click on the schedule appointment link that'll allow you to schedule an appointment.
Okay, I'm gonna jump down. Should digital assets be included in your will?
Yes, people are starting to include digital assets in their wills, and yes, they should be.
Okay, and can the executor be one of your witnesses?
So yes, they can. No, they shouldn't be.
Okay. With the advance directive for healthcare, would you suggest that this should be someone else that isn't in your will or power of attorney?
That's a paranoid question. Many times that's going to be the same person. For example, you're probably going to name your spouse in your will, and that's probably also going to be the person who's going to be your agent. So there's nothing wrong with naming the person who is your agent in your power of attorney or your health or your advance directive in your will, because our circles aren't that big, and sometimes you can't avoid naming the same people.
Okay. So what do you advise for a single person without children or a spouse?
I'm sorry.
Can you hear me? What would you advise for a person without children, relatives, friends to take care of their business? So how would they appoint an executor or something?
Well, if they don't have friends who they could name, that could be hard. They can name an institution. They can name an attorney. I've been named as the executor in a will before. It's a lot of work, so I don't really love it. But they can name either a financial institution or they can name an attorney. But that's a hard one if you don't have any friends either. It's not uncommon for people to not name family members, but typically they would name a friend over their affairs. You could also direct that if you did a trust and you wanted to pass, you still have to name a trustee. And so usually you would name a financial institution.
Okay. What you need, let's see, do you need to have an advance directive, I guess, reviewed if you move to another state?
You should have all of your documents reviewed if you move to another state.
Okay. And would you advise listing every item in your home, assigning every item to a person in your will?
No. One, that's just a lot of work for you. But if you want to, you can, especially if that's important to you, then you should, and we can outline all of those items in the home. The reason I don't necessarily advise it is because, even though people don't like to do wills because they don't like to think about death, most likely you're going to live a very long time after you do your will. And so a lot of the things, if you go about the business of naming individual things in your will be gone. And that could cause a lot of chaos and confusion at your death, because everybody doesn't necessarily know that you got rid of that dresser, or you got rid of that cabinet. So it can be difficult if you name individual things in your will. You can do a memorandum or something in your will saying that if there's a memorandum found identifying things and you want that incorporated, but it's a slippery slope when we start naming everything in the will. For instance, typically we don't name cars in the will. We don't say my 2020, my 2020 Mercedes-Benz. We don't put that in the will because that car could change. So we might say any car that I own at the time of my death. If a person only has one house, we don't typically say my house located at this address. We just say, the house that I own at the time of my death. For when people are leaving everything to their spouse, we don't name what everything is. We just say everything.
And then final question so that we can get to the giveaways. If you die with a will and debt, but your assets are placed in a trust, will your estate be required to pay the debts before the trust is awarded to the recipient?
Yeah, your estate doesn't avoid the debt because the assets are placed in the trust.
Okay, great. For any remaining questions, I guess we'll have you to answer them offline. And when we send this all out to all the participants, they'll have those questions answered as well.
I'd be happy to do it. And like I said, we offer a consultation. So typically any additional questions, you can feel free to reach out to me and I'd be happy to answer them for you.
Awesome. Teresa?
At this time, we will be providing attendees an opportunity to win one of our giveaways.